said in opening, that it's not about the criticism of the company. This is not some elf and safe day. This, he said, is important to protect the members of the public who were present. And how many members of the public were present on that fateful day in February? Not one.
Has everyone voted? Last chance. Well, just so that you know, and I'm sure you do know, it is possible for courts to take a majority verdict, which is just as well, because unanimous we can't quite achieve, especially with so many of you. And in a jury of 12, you need at least 10 people to convict. So we were just doing our maths. That allows for a rate of 16% of objection to the guilty verdict. And so you've got not as much as 16%, so that would be a guilty verdict. If, of course, we had had 17% voting not guilty, that wouldn't have resulted in an acquittal. That would have resulted in a hung jury, and we'd have had to have had a retrial, so we'd have been coming back tomorrow. So as it is, that is a clear guilty verdict. I'm very sorry to say, Mr. Woodford and your company, you've been found guilty. So, we'll move. Yes, Mr. Campbell.
And at this stage, upon conviction, or if, for example, the company pleaded guilty, there'd be two main documents in front of the court. One is a Frisky schedule, which is prepared by the prosecution, which outlines effectively the aggravating and mitigating features. Aggravating features, of course, is the past. Mitigating can be the past, but also the future, such as steps you've taken to remedy, to make sure there was no reoccurrence, etc. From the non-prosecutorial point of view, the most important document is a mitigation bundle. They can be very lengthy. I've got one coming up where it's a proper big, thick lever arch file. The important aspect on sentencing will always be the accounts aspect of that, because the law looks at things in two separate ways, culpability and harm. But the financial penalty, if there were to be one, which is likely in a case like this, it must be high enough to punish the company, but not so high as to effectively put them out of business, not so high as to prevent them from paying for remedial stuff. So you would have, we're having these consultants in, they've recommended these things, especially if you're in a more of a manufacturing situation, where there could be machinery issues, which is going to cost the company X amount of pounds to reinvest to prevent the reoccurrence. All that needs to be documented and put before the court. It shows that you're moving on, but it also shows that the chances of it happening again are reduced if it's machinery, that the culture of a company may well have changed. Now, of course, today was what it was. We didn't get a chance to look at the size of the company, the responsibilities and all that sort of thing. But if we had longer, we would have done so. You'll note that the paper shows he's only got 8 employees. It's a small business. So that one puts more responsibility upon him. But especially in times of austerity, when you have a small business, if you say that a financial penalty which is so great that it would cause you to make redundant 2 members of staff or change them from full-time to part-time, courts will take that into consideration, because that's not just an individual who may have done no wrong, but it's a family who suffer, and mortgages and all the obvious knock-on effects within society. So it's about making sure that the big companies, because now it's unlimited fine, 2 years imprisonment for these sort of offences. The fine, it's unlimited. Before it used to be £20,000. It's unlimited so that your Tesco's, your Morrison's, your Waitrose, etc., don't get limited to a £20,000 fine like they used to. And Joe Bloggs, running a business with a turnover of maybe 120 grand but making profit of 35,000, if that, would end up proportionately being hit with a fine which could actually cripple or crucify them. Those are the things which have changed. Friskish schedules, you will as consultants or as in companies, you engage with those friskish schedule even before you've even pleaded guilty or been convicted. Because it can be a way whereby, one, the prosecution will accept a plea of guilty on a very different basis from what they originally foresaw, because you can show what you've done, the mitigating, and maybe things aren't as aggravating as first thought. But that's something which you need to engage with in your lawyers. And also one of the things which people forget, lawyers in particular forget. The court process itself is a learning experience, is a way in which a company or individuals engage in dealing with any problems they had. And, you know, we see it as in isolation, oh, it's a court, but no. Even the most stubborn company directors can often learn from the court process and see things about their own company which they may not have seen before, because someone coming in from the outside giving them advice, whether it be because of the prosecution or engaging with the health and safety executive, can often ensure that things can work better all round. It's you should never close the door on being able to improve, not because it prevents you from being culpable in law, but actually because it's good business sense, as you all know, more than perhaps we do here. Now probably forced to Gavin to mitigate and not do a plea of aggravation, so hopefully he won't say anything. Any questions about the deliberations or the verdicts?
We do that afterwards.
All right, okay. Go on then, Gavin.
Unless you want to keep going, I don't interrupt your 5-second quick mention.
So yes, we'll take all questions at the end. Mr. Collett, can I start by just going to the sentencing guidelines, please, and just take you through them, because there are various things that we have to I have to consider, aren't there?
There are indeed.
And the first is to consider level of culpability.
Top question.
All right, these are the questions. Okay.
Is Campbell married? Ha! Yes, he is.
Nobody asked bloody me, did they?
Right. Sizist. Yes.
Culpability.
Culpability.
Very high as a deliberate breach or flagrant disregard for the law. I don't think we're in that state. High, offender fell far short of the appropriate standard, for example, by failing to put in place measures that are recognised standards in the industry, ignoring concerns raised by others. Medium, offender fell short of the appropriate standard in a manner that falls between descriptions in high and low, systems in place but not sufficiently adhered to or implemented. Seems to me that that's the level we're at. Would you disagree with me about that?
Medium to low. I think you didn't read out the low. If your honour's made your mind up, then so be it. But certainly it's not high, and you've heard that the... I'm overdoing that. You've heard that the health and safety manual was appropriate, the risk assessment was appropriate, the site induction was appropriate, he'd hired an independent consultant, and indeed it seems that most of the things that he'd done were right. Of course, they weren't implemented, so I cannot argue against the fact that he's been convicted. But medium to low, I certainly don't disagree that it falls in that particular category. I don't think there is terribly much between the two.
Thank you. Now, harm, that's the next category. We've got level A is death, level B is physical or mental impairment.
Well, Mr. Roper was clearly impaired. Yeah.
With a
mentally.
A long-term effect on the sufferer's ability. I don't think I've got the evidence that it's that. It's category C, all other cases. And I then have to consider whether there was a high likelihood of harm, a medium likelihood of harm, how likely I think the harm was to occur from the breaches. What would you say about that, medium or low?
Well, I'd say low, because I mean, clearly it was an unforeseen accident that had those adherence to the correct procedures being applied. It simply wouldn't have resulted in this. This has got to be almost beyond. If you looked at the risk assessment, this is beyond what was being envisaged by that risk assessment, in the very sense that it takes it beyond that thing. I think we are dealing with a low issue, but I mean, I stand to be...
I think I agree with you that the likelihood of an accident happening was low, although the breaches there were a number of breaches which oughtn't to have happened, but the likelihood of those actually resulting in an accident, because Mr. Roper clearly knew how to drive a buggy, even if he'd not been trained.
Well, quite.
So that puts us in harm category 4, following the table. And then I have to consider, don't I, the size of the organisation. Looking at the accounts, it looks to me that we've got what's described as a micro company, which is with a turnover of not more than 2 million. You've got a relatively small company.
Very small. Struggling to get along, Your Honour.
So if we have got medium culpability, harm category 4, with a micro company, the level of fine is between £2,000 and £12,000. But on the other hand, we've actually got a very significant injury that results from it.
Yes, of course, that's been taken care of, and indeed there may well be compensation that I'm sure Mr. Boone will be seeking from the company in due course, and I'm sure we're negotiating with. Unfortunately, as a result of this conviction, I have to say that the MR events, I'm told by my client, the future is not so much bleak as Arctic, insofar as the freezing orders are coming thick and fast. I think the survival of the company into the new year would be highly unlikely.
You got any evidence to that, Mr. Collins?
Look at him. Look at him. Look at him, Your Honour.
Looks pretty cheerful to me.
He's been set upon by his entire group of would-be friends. He's friendless, homeless. I mean, his wife's left him, Your Honour. His children have left him. His dog's left him. I mean, he's going home.
Some might say that's an advantage, Mr. Collins.
Not the dog.
The dog.
Like the dog.
He's only got 3 legs, the dog, because he got injured.
I thought it was just you being hungry. Anyway, the point is, dog eat dog world and that. The point is, he is a broken man. You see a man, you probably don't know, Your Honour, and I think it's only right to say that he and Mr. Boone were very, very close friends. To see his friend laid low by this terrible accident has hurt him terribly. He's undergone some psychiatric testing and the future's not good.
He must have wondered how he could allow it to happen.
No, it's not so much that as he just thought. I think it's the sense of betrayal, the trust he placed in others, the trust he placed in, where's Mr. Roper? The trust he placed in Mr. Roper.
One of the problems I see, Mr. Collett, is that there doesn't seem to be any willingness to accept responsibility on his part.
Madness.
I see that as very much an aggravating feature in this case.
Well,
even now, having heard the almost overwhelming decision of the jury.
Well, what can I say? He's been found guilty.
If you wonder
by his
what
peers.
to say, sometimes the best thing is to say nothing, Mr.
But I know tough audience. Again, I know that Mr. Wood had just wanted to say that he is sorry from the bottom of his heart that his friend Mr. Boone has been injured by that. Well, as he called him, that madman, that reckless man, Mr. Roper, whose devil-may-care attitude has brought his company into such terrible shame. He won't be spoken to by duck drinks again. They feel it's just a step too far. Broken man. I mean, look at him. He's lost, years, gained years as a result of this. His hair's not so much falling out, it's been cut short. He's just a man who has almost no future, nothing to look forward to. Your Honour, what you see before you is the shell of a man, betrayed by those he trusted, let down by those who he thought loved him, except the one that Chris is a great bloke and is innocent, free the one, brother, sister, anonymous. But yes, I think, one can say that somewhere, somebody loves him, but not here. Can I help you?
No, not at all. Well, stand up, Mr. Woodford.
Costs.
As far as the company is concerned, I take the view that, as I have said, the culpability is medium. You had clear policies in place, but your company simply did not do enough and did indeed very little to make sure that they were in place. As I've said, fortunately this injury was not more severe, and perhaps it was a bit of a freak injury. And ordinarily that would put this fine that I would have to impose, given the size of your company, into the bracket of £2,000 to £12,000. But there seems to me very much an aggravating factor that even throughout the evidence, you have not taken responsibility for the actions of your company and for your responsibility in causing a serious injury to your friend. And because of that, I'm going to impose a fine of £20,000 on the company. Thank you very much. Sit down. Now, Mr. Campbell, costs.
Yes, cost of the investigation, Your Honour, under the first schedule, £42,000. Cost of the barrister for today, £64,000. The other issue you have is compensation. As Your Honour knows, that the civil situation is that the injured party is entitled to compensation. He's not entitled to double recovery. He's been laid up now for a year. It may be something which you ought to consider in imposing a sum of compensation today, which of course would be reduced from any civil award he may get, taken so he doesn't get double recovery, but it would ensure that the money was in his pocket within 28 days to ease the burden upon him. And so effectively we would seek a global figure of not less than £10,000. We seek £70,000, but of course how you divvy that up is a matter for you. It's important that the public purse is protected, but more importantly that the victim is compensated sooner rather than later.
So you seek £42,000 in costs and £10,000 by way of compensation?
Yes.
Mr. Collett.
About right.
Beg your pardon?
About right, Your Honour. I think that's about a sensible option. There's not much I can say about that. The cost would be about that. For that trial, for this length, I'm not entirely sure. That's quite light, I think, if it was a proper trial. And in terms of the compensation, well, 10,000 has been suggested. You've already heard what you said about Mr. Boom. I don't think I can argue against that figure.
Well, in those circumstances, that's the award that I will make in relation to costs and compensation. Thank you.
72,000 in total.
Yep. So, that is the end of the trial and sentencing phases. And I think we would be interested in any comments that you've got on the whole process by which you reach your verdict. Yes? Used £1 notes is usually the best way.
That's Swiss bank account they don't know about.
American Express?
Yeah, you'd have to give people payment. So.
I've just been asked to say, by the way, that if you want a copy of those sentencing guidelines, if you leave an email address with Sandra at the back, she can make sure that you have a copy so that you can see how they work. It's quite an interesting, as you see, a very sort of procedural approach to sentencing, a number of clear factors resulting in a table at the end which tells you where the fine should lie.